Hello and welcome to Runkle of the Bailey. My name is Ian Runkle. I'm a Canadian criminal defense and firearms lawyer. Today I want to talk about something that's a little bit controversial, and that is prisoner voting rights. Prisoners in Canada are allowed to vote, and that's including while they're serving their sentences. This has been determined to be protected by Section 3 of the Canadian Charter of Rights and Freedoms, which we'll have a look at as we go through this case. Now, this is a little bit controversial because some people are opposed to the idea of prisoners still getting to vote. And so I thought it'd be useful to go through one of these cases. It's a big case on this issue. It's not the only case, but it's the sort of one that really put the nail in the coffin so that we could look at what the Supreme Court has to say about it and see their reasoning for it. I'm also going to talk a little bit about a reason that the Supreme Court didn't give. And I think it's actually a better reason than what the Supreme Court relied on. So I'll talk about that a little bit as well. But first, I'm going to go through the Supreme Court's reasoning. So let's dive right in. This is the case of Sauve. I'm also going to mention that Mr. Sauve is not the sort of person that people think of as a hero, because he was in custody serving a sentence of life in prison without parole for 25 years, and that was for murder. So not a very sympathetic figure. Nevertheless, he was suing in order to ensure that he could vote, notwithstanding the fact that he was in custody. So let's have a look at this case here. So I'm just going to look at the majority decision. I'm not going to look at the dissent on this one because really I want to keep this as narrow as possible. It was a 5-4 split. At the time, this was, again, fairly controversial. I don't think it would be a 5-4 split now if it were to be relitigated on this issue. So let's have a look here. But so this is the decision of Chief Justice at the time, McLaughlin. The right of every citizen to vote, guaranteed by Section 3 of the Canadian Charter of Rights and Freedoms, lies at the heart of Canadian democracy. The law at stake in this appeal denies the right to vote to a certain class of people, those serving sentences of 2 years or more in a correctional institution. The question is whether the government has established that this denial of the right to vote is allowed under Section 1 of the Charter as a reasonable limit demonstrably justified in a free and democratic society. I conclude that it is not. The right to vote, which lies at the heart of Canadian democracy, can only be trammeled for good reason. Here, the reasons offered do not suffice. So I'm going to read the next paragraph, and then I'll talk a little bit as well as to the history of this, how we came to be in, or how Canada came to be in this particular place for this particular constitutional question. So statutory provisions. The predecessor to Section 51E of the Canada Elections Act prohibited all prison inmates from voting in federal elections, regardless of the length of their sentences. This section was held unconstitutional as an unjustified denial of the right to vote guaranteed by Section 3 of the Charter. Parliament responded to this litigation by replacing this section with a new Section 51E, which denies the right to vote to all inmates serving sentences of 2 years or more. Section 51E, which is now continued in substantially the same form at Section 4C of the Act, and the relevant charter provisions are set out below. So what happened is initially the law said if you're serving a sentence at all, no matter how short, that you were banned from voting. And that was struck down as unconstitutional. So the government said, okay, if that's too far, how about if we just ban everyone serving more than 2 years? So if you're getting a 30-day sentence for, some minor shoplifting or something, and that happens to fall on election day, then you're not going to be banned from voting. So that was sort of their attempt at a compromise. And this is somewhat important for the reasoning here, because this falls into a sort of general theory of government relationship with the courts, and that is the dialogue theory, which is basically that the government tries to do something and the courts say, no, you can't. That's actually against the Constitution. And so the government comes back and says, well, we really think it's important. How about if we do something, a little less serious? Can we do that? And so there's this kind of weird judicial banter, if you can sort of frame it that way, between the government and the courts as the government tries to do what they want. And the courts will say, okay, listen, that's fine. That's not against the Constitution, or, whoa, no, you can't. So that was part of what's going on, and the government is going to be making some dialogue-related arguments in the course of this. All right, let's keep on going here. This is the previous provisions that they were talking about here. So, Canada Elections Act, the following persons are not qualified to vote at an election and shall not vote at an election. E. Every person who is imprisoned in a correctional institution serving a sentence of 2 years or more. So, as I mentioned, that has been struck down as unconstitutional, but in order to examine this, they were quoting it just so that we all know what the law is that they're examining. So, and they're going to also quote a couple of sections of the Canadian Charter of Rights and Freedoms. The first is Section 1, and this is the General Limitations Clause, because the Charter is not a document of absolute rights. Section 1 is itself somewhat controversial, but it has been described as kind of fundamental to the Canadian rights framework, and I could do probably several videos on how Section 1 ends up really shaping our constitutional and charter litigation. But for now, I'll just sort of go through and note, it says the Canadian Charter of Rights and Freedoms guarantees the rights and freedoms set out in it, subject only to such reasonable limits prescribed by law as can be demonstrably justified in a free and democratic society. So if you break that down, it's got several portions to it. It guarantees the rights and freedoms in it, subject only to limitations that must be prescribed by law, which means there has to be an actual law about it. It can't just be somebody's arbitrary decision. And they have to be demonstrably justified. Now, there's case law on what that means. And demonstrably means less evidence than most people might think. It can often just be sort of a concern, if that makes sense, in a free and democratic society. So that basically says it puts a sort of framework or a flavor to what demonstrably justified means. It has to be justifiable, but also in the sense of respecting that we have rights and so forth. So that is a limitation clause that applies to pretty much all other rights in there. So no right in the Charter is absolute. But the next right they specify is Section 3. Every citizen of Canada has the right to vote in an election of members of the House of Commons or of a legislative assembly and to be qualified for membership therein. So that is real broad, right? Every citizen of Canada has the right to vote in an election. Full stop. They don't put any limitations on that. So the only limitations would be the ones found in Section 1, whatever reasonable limits are prescribed by law. The government was arguing, of course, that the limitation barring prisoners who were serving 2 years or more was a reasonable limit. And as you've already seen, the court says, nah, it isn't. Now, I'm not going through Section 15, which is every individual is equal before and under the law. That's the anti-discrimination provision. There were arguments made about this at the Supreme Court in this decision, but the court rules based on Section 3, and they say essentially, we don't need to look at the Section 15 stuff because we already found that the right exists. So they don't actually examine that question, so I'm not going to cover the Section 15 stuff. So judgments, this is a bit of the procedural history in terms of how this case works its way up to the Supreme Court. So the trial judge, Wetson, held that Section 51 of the Canada Elections Act violated the Charter guarantee of the right to vote without being demonstrably justified and was therefore void. Although he found that the government's objectives were pressing and substantial, he concluded that the denial of voting rights to all inmates serving a sentence of 2 years or longer was overbroad and failed the minimal impairment test. In addition, he found at page 913, you can see why I'm not going through that decision, that denying the right to vote hindered the rehabilitation of offenders and their successful reintegration into the community. The negative consequences of the challenge provision were thus disproportionate to any benefits it might produce. Now, after that decision, it goes on to the Federal Court of Appeal. And the majority of the Federal Court of Appeal, per Linden, reversed the trial judge and upheld the denial of voting rights, holding that Parliament's role in maintaining and enhancing the integrity of the electoral process and in exercising the criminal law power both warranted deference. So deference means essentially that you give them some credit. You kind of tip the scale a little bit in favor of Parliament here. So there's going to be some commentary on that in this decision. The denial of the right to vote at issue fell within a reasonable range of alternatives open to Parliament to achieve its objectives and was not overbroad or disproportionate. Desjardins, applying the stringent formulation of the Oakes test, emphasized the absence of evidence of benefits flowing from the denial and would have dismissed the appeal. So there was a dissenting justice at the Court of Appeal. All right, so continuing on here, the issues is just, does it infringe the guarantee of all rights, the right of all citizens to vote? And if so, is the infringement justified? And there's also question 2 of, does it infringe the equality guarantee of section 15 sub 1? As noted, the court doesn't actually address that second point. They determine that they don't have to. And the Supreme Court doesn't typically entertain questions that are not central. If they don't have to answer a question, they will typically not. They try to keep their decisions economical, if you can sort of imagine it that way. They try to have efficiency in their rulings. So analysis. The respondents concede that the voting restriction at issue violates Section 3 of the Charter. The restriction is thus invalid unless demonstrably justified under Section 1. I shall therefore proceed directly to the Section 1 analysis. So what this means is that the Government of Canada, in arguing this, started out by saying, listen, we agree that it violates Section 3. And you might be wondering, why would they do that? Well, in this case, because the wording of Section 3 is so obvious, they're not going to be able to make the argument that it doesn't without looking dumb. They're not going to come in and, make that argument and lose credit with the court. So this was quite a proper concession, because really what they're arguing here is that they're saying, yeah, we are denying the right to vote to some people who would otherwise be included under Section 3, but we think it's justified. And so they're really narrowing the issue. This is a sensible concession, notwithstanding the fact that it may look like a big concession. They weren't really giving up an arguable issue on this one. So the approach to Section 1 justification. The court is going to explain what it means to be justified, a justified limit under Section 1. To justify the infringement of a charter right, the government must show that the infringement achieves a constitutionally valid purpose or objective, and that the chosen means are reasonable and demonstrably justified. That's the Oakes test. The Oakes test is really important if you're looking at any constitutional litigation. It is fundamental, and I should probably do a video on it at some point. This two-part inquiry, the legitimacy of the objective and the proportionality of the means, ensures that a reviewing court examine rigorously all aspects of justification. Throughout the justification process, the government bears the burden of proving a valid objective and showing that the rights violation is warranted. That is, that it is rationally connected, causes minimal impairment, and is proportionate to the benefit achieved. So it's got to hit those boxes, essentially. My colleague, Justice Gontier, proposes a deferential approach to infringement and justification. He argues that there is no reason to accord special importance to the right to vote, and that we should thus defer to Parliament's choice among a range of reasonable alternatives. He further argues that in justifying limits on the right to vote under Section 1, we owe deference to Parliament because we're dealing with philosophical, political, and social considerations, because of the abstract and symbolic nature of the government's stated goals, and because the law at issue represents a step in a dialogue between Parliament and the courts. There's that dialogue argument that I mentioned, right? Now, I'll just mention here that when you see in Supreme Court decisions, often the majority decision and the dissent don't mention each other. They kind of are two ships passing in a fog, and they don't, each side makes their argument, but they don't talk about the other side. And that's because this is kind of, it's not a thing they always do, where they kind of, point out the other side and say, hey, listen, we think you're wrong for these reasons. So this is a little, not unusual, but it's different than some other cases. And that's probably because this was a 5-4 split and on a really contentious issue. So they really want to say, let's look at the reasoning on this one. So the Chief Justice continues, I must, with respect, disagree. The right to vote is fundamental to our democracy and the rule of law and cannot be lightly set aside. Limits on it require not deference, but careful examination. This is not a matter of substituting the court's philosophical preference for that of the legislature, but of ensuring that the legislature's proffered justification is supported by logic and common sense. The Charter distinguishes between two separate issues: whether a right has been infringed and whether the limitation is justified. The complainant bears the burden of showing the infringement of a right, the first step, at which point the burden shifts to the government to justify the limit as a reasonable limit under Section 1. So this is kind of an important aspect. If you are going to the court to say the government has violated my rights, the process in terms of establishing that's the case is you first have to establish that there was a right that was violated. That burden is on you at the outset. But once you meet that test and the government wants to defend that violation as a reasonable limitation under Section 1, they bear the burden of establishing that it's a reasonable limit. So that's what the court is talking about here. These are distinct processes with different burdens. Insulating a rights restriction from scrutiny by labeling it a matter of social philosophy, as the government attempts to do, reverses the constitutionally imposed burden of justification. It removes the infringement from our radar screen instead of enabling us to zero in on it to decide whether it is demonstrably justified as required by the Charter. So the court is saying, listen, if we accept this mode of thinking, that we essentially change that so that the burden is always on the person whose rights are being violated or who is saying their rights are violated. So we can't do that. That would upend our processes and essentially permit too many violations of rights to go through. So at the first stage, which involves defining the right, we must follow this court's consistent view that rights shall be defined broadly and liberally. And they cite some cases there, including Big M Drug Mart, Eldridge. I haven't gone through any of those cases in my videos, but maybe I should at some point. A broad and purposive interpretation of the right is particularly critical in the case of the right to vote. The framers of the Charter signaled the special importance of this right, not only by its broad, untrammeled language, but by exempting it from legislative override under Section 33's notwithstanding clause. I conclude that Section 3 must be construed as it reads, and its ambit should not be limited by countervailing collective concerns, as the government appears to argue. These concerns are for the government to raise under Section 1 in justifying the limits it has imposed on the right. So this is an important thing, because the court is saying here that the voting right is a special right, that it occupies a place of privilege among all the other rights. And one of the things that they point to is the fact that Section 33, the notwithstanding clause that otherwise allows the government to essentially turn off certain rights in some, if by means of specially passed legislation, they can't use that against voting rights. Now, why would they have specifically excluded voting rights from Section 33's notwithstanding clause? If you think about that one, the reason for that is kind of obvious. You don't want the government to be able to say, listen, we don't think that people in Eastern Canada are going to vote for us, so we're just going to take the entirety of the Maritimes and say that they don't get to vote via the notwithstanding clause. I mean, that would be really messed up, and you can see why a government would have the sort of urge to do that, but how that would take us tremendously far away from what we call a free and democratic society. So that's probably why Section 3, the voting rights, was not included under Section 33, the notwithstanding clause. And I'll get to some of those issues a little later on as well. All right, I'm going to carry on here. As per usual, I'm skipping over a whole bunch of stuff just for time, because this is going to be a long video, and I'm sorry about that, but covering sort of in-depth, detailed issues tends to be long. But I will link to the full decision so that you can check it out yourself and read it if you want. So Section 1 does not create a presumption of constitutionality for limits on rights. Rather, it requires the state to justify such limitations. So the burden is on the government, and that's important. The core democratic rights of Canadians do not fall within a range of acceptable alternatives, among which Parliament can pick and choose at its discretion. Deference may be appropriate on a decision involving competing social and political policies. It is not appropriate, however, on a decision to limit fundamental rights. This case is not merely a competition between competing social philosophies. It represents a conflict between the right of citizens to vote, one of the most fundamental rights guaranteed by the Charter, and Parliament's denial of that right. Public debate on an issue does not transform it into a matter of social philosophy, shielding it from full judicial scrutiny. It is for the courts, unaffected by the shifting winds of public opinion and electoral interests, to safeguard the right to vote guaranteed by Section 3 of the Charter. So rights you don't lose a right if it becomes unpopular, is what they're saying here. And that's an important role of the courts, is that they're not going to be deciding based on popularity or whether or not it gets a government reelected. They decide based on what the Charter protects. So Charter rights are not a matter of privilege or merit, but a function of membership in the Canadian polity that cannot lightly be cast aside. This is manifestly true of the right to vote, the cornerstone of democracy, exempt from the incursion permitted on other rights through Section 33 override. Nor can I concur in the argument that the philosophically based or symbolic nature of the government's objectives in itself commands deference. To the contrary, this court has held that broad, symbolic objectives are problematic. Parliament cannot use lofty objectives to shield legislation from Charter scrutiny. Section 1 requires valid objectives and proportionality. And the reason why they're mentioning this is that the government's arguments basically had some big, broad, vague kind of objectives that they were saying justify this. We need this because, to promote respect for the electoral system. Well, that sounds nice. What does that actually mean? What couldn't you justify under that category? So they're saying, come on. Finally, the fact that the challenged denial of the right to vote followed judicial rejection of an even more comprehensive denial does not mean that the court should defer to Parliament as part of a dialogue. Parliament must ensure that whatever law it passes, at whatever stage of the process, conforms to the Constitution. The healthy and important promotion of a dialogue between the legislature and the courts should not be debased to a rule of, if at first you don't succeed, try again. Keep in mind, this is a response to the minority in this one. So, to the dissenting judgment. So this is a little bit of tension that you can see among the court. This is a bit of banter. It's an emphatic rejection of the minority decision. I'll frame it that way. So continuing on here, while deference to the legislature is not appropriate in this case, legislative justification does not require empirical proof in a scientific sense. While some matters can be proved with empirical or mathematical precision, others involving philosophical, political, and social considerations cannot. In this case, it is enough that the justification be convincing, in the sense that it is sufficient to satisfy the reasonable person looking at all the evidence and relevant considerations that the state is justified in infringing the right at stake to the degree it has. However, one must be wary of stereotypes cloaked as common sense, and of substituting deference for the reasoned demonstration required by Section 1. So they basically said, yeah, no, we don't owe you any deference on this one. You've got to get it right. It's not a matter of within a realm of reasonable alternatives. You've got to actually land on the right alternative here. So it is a strident protection of a right that we see in this particular decision. So the government's objectives. This is how the government is trying to defend this limitation on voting. The objectives analysis entails a two-step inquiry. First, we must ask what the objectives are of denying penitentiary inmates the right to vote. This involves the interpretation and construction and calls for a contextual approach. Second, we must evaluate whether the objectives as found are capable of justifying limitations on charter rights. The objectives must not be trivial, and they must not be discordant with the principles integral to a free and democratic society. So if you think about, objectives must not be trivial. It can't be something like, listen, we really just think that this is aesthetically unpleasing. If you wanted to ban the color blue in art because you don't like it, that would be a trivial objective and couldn't justify that limitation on free speech. And in terms of they must not be discordant with the principles integral to a free and democratic society. If you wanted to limit a right in a way that was discriminatory, for instance, that because, you're saying these particular category of people are people we dislike, that would, be discordant with the principles to a free and democratic society. So at least that's sort of the example that leaps to mind. Because Section 1 serves first and foremost to protect rights, the range of constitutionally valid objectives is not unlimited. For example, the protection of competing rights might be a valid objective. However, a simple majoritarian political preference for abolishing a right altogether would not be a constitutionally valid objective. So this is basically saying, listen, just because you get 50% of the vote plus one voter doesn't mean that you can start stepping on charter rights. Charter rights are intended to be a protection in part from what the majority of the electorate might do. So that's an important consideration here, and the court is quite properly, I think, echoing that. Continuing on here, Section 51, denying penitentiary inmates the right to vote, was not directed at a specific problem or concern. Prisoners have long voted, here and abroad, in a variety of situations without apparent adverse effects to the political process, the prison population, or society as a whole. In the absence of a specific problem, the government asserts two broad objectives as the reason for this denial of the right to vote. And I'll just stop here because one concern people have when they address prisoners voting is they say, listen, if you build a prison somewhere, isn't that going to create this sort of super seat that is basically entirely prisoners? And we actually get around that here in Canada with a fairly simple system, which is that prisoners don't vote as being residents of the prison. They vote as being residents of their sort of ordinary place of residence. And there's a variety of ways to get around that or to determine that. The first criterion is basically, where were you ordinarily living before you were incarcerated? And the next one, if you don't have a place, say you were, transient, you were, traveling across Canada back and forth all the time, you never really laid down any roots. The next question is, where's your spouse living? And that one makes some sense, right? Because that is a tie to a specific community if your spouse is living in a particular place. But if you can't use that, they may use, I think the next one is where you were arrested, so where you were actually picked up. And I think the last criterion, and this is from memory, so I may be getting it wrong, but I think the last criteria for determining where you're ordinarily resident is the courthouse where you were sentenced. So you can see you've got this list of things to determine where ordinarily resident was, and that means that all of the prisoners in Canada don't end up voting from these little tiny prison jurisdictions. So what that means ultimately is that prisoners don't skew the vote in any really big way. They're a tiny percentage of the electorate. So that's, that avoids that problem. And so the government wasn't able to point to that as an issue. And if they had, the court probably would have said, figure out a different way. So let's continue on with their reasons. So 1, to enhance civic responsibility and respect for the rule of law. Don't we all want to respect the rule of law? Yeah, but what does that actually mean here, right? So you can see why the court had some trouble with this. And 2, to provide additional punishment or enhance the general purpose of the criminal sanction. The record leaves in doubt how much these goals actually motivated Parliament. The parliamentary debates offer more fulmination than illumination. So that's a little bit of clever wordplay. Fulmination here just means that they were shouting at each other. And so they and this is something that the court can do when they're actually trying to decide what the purpose of a law is. They can actually go back and look at the parliamentary record, what we call the Hansard, in order to determine whether or not, what a particular law was justified by. So that is what they were doing there, but they're saying it's not helpful. Everyone was yelling at each other. Nobody was making a whole lot of sense. So these seem like reasons that might be coming in after the fact rather than ones that were, grounding Parliament's decision. However, on the basis of some glimmer of light, The trial judge at page 878, again, you see why I'm not looking at the trial judge here, concluded that they could be advanced as objectives of the denial. I'm content to proceed on this basis. So some glimmer of light, you can already see where the court's going. You're not going to describe somebody's objectives as, some glimmer of light if they're going to be held as valid objectives. This is basically the court saying, okay, you guys are making an argument that is not completely ridiculous. Let's look at it in order to examine it. This leaves the question of whether the objectives of enhancing respect for law and appropriate punishment are constitutionally valid and sufficiently significant to warrant a rights violation. Vague and symbolic objectives such as these almost guarantee a positive answer to the question. Who can argue that the respect for the law is not pressing? Who can argue that proper sentences are not important? Who can argue that either of these goals, taken at face value, contradict democratic principles? However, precisely because they leave so little room for argument, vague and symbolic objectives make the justification analysis more difficult. Their terms carry many meanings, yet tell us little about why the limitation on the right is necessary and what is expected to achieve it in concrete terms. The broader and more abstract the objective, the more susceptible it is to different meanings in different contexts, and hence to distortion and manipulation. One articulation of the objective might inflate the importance of the objective, another might make the legislative measure appear more narrowly tailored. The court is left to sort the matter out. I'm going to try to translate this because that was some dense legalese. Essentially, the court is saying this is bullshit. That you guys are giving a vague objective and, really you got to narrow it down a little bit to help the court out. The court's never going to use, is never going to say something is bullshit in a decision unless they're talking about something like, sovereign citizens or something way out there. And they're never going to refer to the government position that way. But it's clear that there is not a whole lot of... The court doesn't have much appetite for what the government is serving up here. At the end of the day, people should not be left guessing about why their charter rights have been infringed. Demonstrable justification requires that the objective clearly reveal the harm that the government hopes to remedy, and that this objective remain constant throughout the justification process. If Parliament can infringe a crucial right, such as the right to vote, simply by offering symbolic and abstract reasons, judicial review either becomes vacuously constrained or reduces to a contest of our symbols are better than your symbols. Neither outcome is compatible with the vigorous justification analysis required by the Charter. So the court is really not liking this vague objective stuff. The rhetorical nature of the government objectives advanced in this case renders them suspect. The first objective, enhancing civic responsibility and respect for the law, could be asserted of virtually every criminal law and many non-criminal measures. Respect for the law is undeniably important, but the simple statement of this value lacks the context necessary to assist us in determining whether the infringement at issue is demonstrably justifiable in a free and democratic society. And you get the sense from, going through all of this that they kind of think that these justifications weren't the actual justifications, but are kind of back defenses, that they wanted to uphold this law because it's politically convenient and expedient. The voting public doesn't tend to like prisoners. They're not popular people. Mr. Sauve in particular, who was a member of Satan's Choice and in custody for murder, is not a popular guy. And there's lots of things you could have, convinced the voting public to do to Mr. Sauve, but you still need to justify why. And so that's, they're saying basically, we don't think that this is a justification that really guided your thinking. We think it's a sort of a defense in the sense of, a justification come up after the fact in order to try to support a law that is otherwise pretty tenuous. That's the feeling I get from how the majority here worded the decision. So the second objective, to impose additional punishment on people serving penitentiary sentences, is less vague than the first. Still, problems with vagueness remain. The record does not disclose precisely why Parliament felt that more punishment was required for this particular class of prisoner, or what additional objectives Parliament hoped to achieve by this punishment that were not accomplished by the sentences already imposed. This makes it difficult to assess whether the objective is important enough to justify an additional rights infringement. Quite simply, the government has failed to identify particular problems that require denying the right to vote, making it hard to say that the denial is directed at a pressing and substantial purpose. Nevertheless, despite the abstract nature of the government's objectives and the rather thin basis upon which they rest, prudence suggests that we proceed to the proportionality analysis rather than dismissing the government's objectives outright. The proportionality inquiry allows us to determine whether the government's asserted objectives are in fact capable of justifying its denial of the right to vote. At that stage, as we shall see, the difficulties inherent in the government's stated objectives become manifest. So they already are not liking the objectives, and they're basically just proceeding on for the sake of argument. The government has advanced these arguments. We're going to tear them apart in turn, and we're going to be thorough about it, notwithstanding the fact that we think that they're trash from the outset. Okay, carrying on to see how they conduct a proportionality analysis. Now, I could probably, there's probably going to be some people who say, Runkle, you're 35 minutes in. Why not stop here? We already know that they're going to lose. Well, I think it's important for us to go through and look at the analysis and see why they made this decision, because again, this is a controversial aspect of Canadian society. You see people say, why do we let prisoners vote? So I think it's worth going through all of that. The second thing is that just by going through the process, we can learn about what the process looks like. They're doing the Oakes test. And so, in terms of seeing how the court addresses this kind of rights issue, I think has some value to it. So that's why I'm carrying on. But continuing on here, proportionality. At this stage, the government must show that the denial of the right to vote will promote the asserted objectives, the rational connection test, and that the denial does not go further than reasonably necessary to achieve its objectives, the minimal impairment test, and that the overall benefits of the measure outweigh its negative impact, the proportionate effect test. So there's 3 separate subtests there. As will be seen, the vagueness of the government's justificatory goals, coupled with the centrality of the right to vote to Canadian democracy, the rule of law, and legitimate sentencing, make the government's task difficult indeed. And in fact, if you were government counsel and you've gotten this far in listening to the decision, you already know you've lost. So carrying on here, rational connection. So this basically says that the law has to do what it promises to do. Is it actually going to promote its asserted objectives? Let's say that I want to pass a law and I think it's really important. The objective that I'm trying to say is to promote freedom of expression and the flourishing of the arts. So that's those are laudable objectives, if perhaps a little vague. But let's say that the way I'm going to do that is instead by jailing everyone who doesn't, whatever. It's hard to see how jailing people is going to promote free expression and art, so that disconnect is something that the court will not permit. That's what they're looking at with the rational connection aspect. So the government must show that this is likely either by evidence or in reason and logic. The government advances 3 theories to demonstrate rational connection between its limitation and the objective of enhancing respect for law. First, it submits that depriving penitentiary inmates of the vote sends an educative message about the importance of the respect of law to inmates and to the citizenry at large. Second, it asserts that allowing penitentiary inmates to vote demeans the political system. Finally, it takes the position that disenfranchisement is a legitimate form of punishment, regardless of the specific nature of the offense or the circumstances of the individual offender. In my respectful view, none of these claims succeed. Okay, so we already know what's going to happen. Let's see why it happens. The first asserted connector with enhancing respect for the law is the educative message or moral statement theory. And the court says, denying penitentiary inmates the right to vote misrepresents the nature of our rights and obligations under the law and consequently undermines them. In a democracy such as ours, the power of lawmakers flows from the voting citizens, and lawmakers act as the citizens' proxies. This delegation from voters to legislators gives the law its legitimacy or force. Correlatively, the obligation to obey the law flows from the fact that the law is made by and on behalf of the citizens. So what the court is saying is, you're trying to teach people civics by this method, but your civics are bad. You don't understand this. Parliament gains its power from the people, not people from the parliament. And so Parliament, saying we're going to take away your right to the vote to teach you a lesson about the importance of the system is teaching people a false lesson. It's wrong. So that's what the court is starting, that's how they reject the educative message thing. Reflecting this truth, the history of democracy is the history of progressive enfranchisement. The universal franchise, so everyone gets to vote, has become, at this point in time, an essential part of democracy. From the notion that only a few meritorious people could vote, expressed in terms like class, property, and gender, there gradually evolved the modern precept that all citizens are entitled to vote as members of a self-governing citizenry. So, again, we are a free and democratic society. We have universal suffrage. Everyone gets to vote, and we're not going backwards on that. Under Section 3 of the Charter, the final vestiges of the old policy of selective voting, because originally voting was limited to people who had property and to men and, to these kinds of things. So under Section 3 of the Charter, the final vestiges of the old policy of selective voting have fallen, including the exclusion of persons with a mental disease and federally appointed judges. Yeah, that's a joke that kind of writes itself there. I'm just gonna skip on, but the phrasing on that one is, yeah, you get it. I'm just gonna move on. I would not have phrased it that way. The government's vague appeal to civic responsibility is unhelpful, as is the attempt to lump inmate disenfranchisement together with legitimate voting regulations in support of the government's position. The analogy between youth voting restrictions and inmate disenfranchisement breaks down because the type of judgment Parliament is making in the two scenarios is very different. In the first case, Parliament is making a decision based on the experiential situation of all citizens when they are young. It is not saying that the excluded class is unworthy to vote, but regulating a modality of the universal franchise. Now, this is something that people disagree on, but I'm not going to go into it in too much detail, but they're basically saying, listen, age and, prisoner status are not similar. I agree with that aspect, but in terms of the experiential situation, I'm not sure that that one can really be held up in light of the universal franchise elements. There might be other better arguments for, limiting the vote, but I'm going to end up too far afield if I get into youth voting in this one. The theoretical and constitutional links between the right to vote and respect for the rule of law are reflected in the practical realities of the prison population and the need to bolster rather than undermine the feeling of connection between prisoners and society as a whole. The government argues that disenfranchisement will educate and rehabilitate inmates. However, disenfranchisement is more likely to become a self-fulfilling prophecy rather than a spur to reintegration. So this is, most prisoners are going to get out one day. And so we want to make sure that those prisoners have a connection to society, something to help ensure that they're going to get out and not commit further offenses that land them back in prison. So we want to promote a sense of connection with the larger society. That's what the court is saying here. And that voting can help with that. And cutting people off from voting is just going to make people feel more alienated and more distant and unconcerned. And that's not helpful. So even if these difficulties could be overcome, it is not apparent that denying penitentiary inmates the right to vote actually sends the intended message to prisoners or to the rest of society. People may be sentenced to imprisonment for 2 years or more for a wide variety of crimes, ranging from motor vehicle and regulatory offenses to the most serious cases of murder. The variety of offenses and offenders covered by the prohibition suggests that the educative message is at best a mixed and diffuse one. I conclude that denying penitentiary inmates the right to vote is more likely to send messages that undermine respect for the law and democracy than messages that enhance those values. The government's novel political theory that would permit elected representatives to disenfranchise a segment of the population finds no place in a democracy built upon principles of inclusiveness, equality, and citizen participation. That not all self-proclaimed democracies adhere to this conclusion says little about what the Canadian vision of democracy embodied in the Charter permits. Punitive disenfranchisement of inmates does not send the educative message that the government claims. To the contrary, it undermines this message, and it is incompatible with the basic tenets of participatory democracy contained in and guaranteed by the Charter. So that is real thorough there. So they also note, the government also argues that denying penitentiary inmates the right to vote will enhance respect for law because allowing people who flaunt the law to vote demeans the political system. The same untenable premises we've been discussing resurface here, that voting is a privilege the government can suspend, and that the commission of a serious crime signals that the offender has chosen to opt out of community membership. But beyond this, the argument that only those who respect the law should participate in the political process is a variant on the age-old unworthiness rationale for denying the vote, which the court, as you can see, does not agree with. The idea that certain classes of people are not morally fit or morally worthy to vote and to participate in the lawmaking process is ancient and obsolete. Edward III pronounced that citizens who committed serious crimes suffered civil death, by which a convicted felon was deemed to forfeit all civil rights. Until recently, large classes of people, prisoners among them, were excluded from the franchise. The assumption that they were not fit or worthy of voting, whether by reason of class, race, gender, or conduct, played a large role in this exclusion. So, as Arbour stated in Sauve number 1, so the first case on voting rights, since the adoption of Section 3 of the Charter, it is doubtful that anyone could now be deprived of the vote on the basis that he or she was not decent or responsible. So this brings us to the government's final argument for rational connection, that disenfranchisement is a legitimate weapon in the state's punitive arsenal against the individual lawbreaker. Again, the argument cannot succeed. The first reason is that using the denial of rights as punishment is suspect. The second reason is that denying the right to vote does not comply with the requirements for legitimate punishment established by our jurisprudence. The argument, stripped of rhetoric, proposes that it is open to Parliament to add a new tool to its arsenal of punitive implements, denial of constitutional rights. I find this notion problematic. I do not doubt that Parliament may limit constitutional rights in the name of punishment, provided that it can justify the limitation. But it is another thing to say that a particular class of people for a particular period of time will completely lose a particular constitutional right. This is tantamount to saying that the affected class is outside the full protection of the Charter. It is doubtful that such an unmodulated deprivation, particularly of a right as basic as the right to vote, is capable of justification under Section 1. Could Parliament justifiably pass a law removing the right of all penitentiary prisoners to be protected from cruel and unusual punishment? Which is, of course, when you think about it, that's a right intended to protect prisoners, right? Intended to protect convicts from certain kinds of punishment. So could they say as punishment, we're going to suspend that right and then, subject you to cruel and unusual punishment? So what the court says is, I think not. What of freedom of expression or religion? Why, one asks, is the right to vote different? The government offers no credible theory about why it should be allowed to deny this fundamental democratic right as a form of state punishment. When the facade of rhetoric is stripped away, little is left of the government's claim about punishment, other than that criminals are people who have broken society's norms and may therefore be denounced and punished as the government sees fit, even to the point of removing fundamental constitutional rights. Yet the right to punish and to denounce, however important, is constitutionally constrained. It cannot be used to write entire rights out of the Constitution, it cannot be arbitrary, and it must serve the constitutionally recognized goals of sentencing. On all counts, the case that Section 51E furthers lawful punishment objectives fails. I conclude that the government has failed to establish a rational connection between Section 51E's denial of the right to vote and the objectives of enhancing respect for the law and ensuring appropriate punishment. So, once again, they could stop here and say, that's it, you failed that test, we're done the analysis. But they're keeping going, so we're going to keep going. I promise this won't be too long, but it's already fairly long. So, minimal impairment. The question at this stage of the analysis is not how many citizens are affected, but whether the right is minimally impaired. So they're drawing an important distinction here. They're saying, listen, the government had made the argument that, listen, we're affecting fewer people. You said that we couldn't ban all prisoners from voting, so now we've narrowed it so there's fewer people who are affected. The court is rejecting this argument. Even one person whose charter rights are unjustifiably limited is entitled to seek redress under the charter. It follows that this legislation cannot be saved by the mere fact that it is less restrictive than a blanket exclusion of all inmates from the franchise. The only real answer the government provides to the question, why 2 years, is because it affects a smaller class than would a blanket disenfranchisement. So that's not terribly convincing. Nor is it any answer to say that the infringement will end when the imprisonment ends. The denial of the right to vote during the period of imprisonment affects penitentiary inmates consistently to an absolute degree and in arbitrary ways that bear no necessary relation to their actual situation or attitude towards state authority. Section 51 sub 3 thus denies a prisoner's rights in precisely the same fashion as its unconstitutional predecessor. So again, they lose on that point too. On to proportionate effect, where they're going to lose again. The government is having a real bad day in this case. If a connection could be shown between the denial of the right to vote and the government's objectives, the negative effects of denying citizens the right to vote would greatly outweigh the tenuous benefits that might ensue. Denial of the right to vote to penitentiary inmates undermines the legitimacy of government, the effectiveness of government, and the rule of law. It curtails the personal rights of the citizen to political expression and participation in the political life of his or her country. It countermands the message that everyone is equally worthy and entitled to respect under the law, that everybody counts. It is more likely to erode respect for the rule of law than to enhance it, and more likely to undermine sentencing goals of deterrence and rehabilitation than to further them. The government's plea of no demonstrated harm to penitentiary inmates rings hollow when what is at stake is the denial of the fundamental right of every citizen to vote. When basic political rights are denied, proof of additional harm is not required. So essentially what the government had been arguing here is, listen, you can't show that not voting is hurting these particular inmates. You know, they're just fine not voting. They're not suffering anything. But what the government or what the court is responding with is, listen, the denial of the right is itself a harm. You can't just say, okay, well, you're fine without that right. Taking that right away is in itself a harm that the government is just not permitted to impose without good reasons. So they continue on to say, were proof needed, it is available. I'm going to skip over that here. So the negative effects of Section 51E upon prisoners have a disproportionate effect on Canada's already disadvantaged Aboriginal population, whose overrepresentation in prisons reflects a crisis in the Canadian criminal justice system. And that's the Queen and Gladue. To the extent that the disproportionate number of Aboriginal people in penitentiaries reflects factors such as higher rates of poverty and institutionalized alienation from mainstream society, penitentiary imprisonment may not be a fair or appropriate marker of the degree of individual culpability. Added to this is the cost of silencing the voices of incarcerated Aboriginal people. With due respect, the fact that 1,837 Aboriginal people are disenfranchised by this law, while close to 600,000 are not directly affected, does not justify restricting the rights of those 1,837 individuals for reasons not demonstrably justified under the Charter. See the Court of Appeal decision at paragraph 169. Aboriginal people in prison have unique perspectives and needs, yet Section 51E denies them a voice at the ballot box and by proxy in Parliament. That these costs are confined to the term of imprisonment does not diminish their reality. The silenced messages cannot be retrieved, and the prospect of someday participating in the political system is cold comfort to those whose rights are denied in the present. So once you've prevented somebody from voting in a particular election, they can't go back when they're released and vote in it retroactively, right? That's not available. So they're saying this is an unfixable problem. This is as close as the court gets to addressing one of the arguments that was made here, which was that this is systematically discriminating against Indigenous people in Canada. So the court mentions it, but they don't end up ruling on that basis, other than this paragraph here. They otherwise skip over the Section 15 aspects. So they note, they say it's unnecessary to consider the alternative argument that it infringes the equality guarantee of Section 15 sub 1. So I would allow the appeal with cost to the appellants. So Mr. Sauve and really probably his lawyers got costs paid to them. Section 51E infringes Section 3 of the Charter, and the infringement is not justified under Section 1. It follows that Section 51E is inconsistent with the Charter and is of no force or effect by operation of Section 52 of the Constitution Act 1982. So they would answer the constitutional questions as follows. First, does it infringe the right to vote? Yes. Second, is the infringement a reasonable limit prescribed by law, which can be demonstrably justified in a free and democratic society? The answer to that is no. And so they don't go on to address the additional constitutional questions. I am not, as I said, going to cover the dissent here. That's the minority position. It's the losing side, so I'm not going to look at it here. But they covered a whole bunch of issues here in terms of the educative value and in terms of, whether or not the government kind of justified all of this. And to me, one of the big issues that was kind of left on the table and was kind of not addressed is one of incentives. And they get close to it. They sort of tiptoe up to it without really addressing it. And when I say the issue of incentives, I mean the fact that the government is, there's an issue in terms of the government may have a desire to prevent certain people from voting, especially people who are associated with classes or, subgroups of society, and that may be subgroups that are protected by Section 15, in terms of races or genders or whatever else. But it might also be just different groups of people who are, who view things in a particular way. And so if you identify that, for instance, people who work in the oil patch, are less likely to vote for the party in power, they might have an incentive to try to find a way to prevent those people from voting. And that's a concern that I have in terms of what governments might do. We can't presume that governments are going to act reasonably or fairly, because there is a substantial history of governments acting outside of that in ways that may be self-serving rather than serving the public. And one thing that is clear when we look at some other countries is that in some places, the ability to use the criminal justice system to deny votes has been used in a systematic way to target political enemies. And I think that that is a terrible thing. The criminal justice system should be used only for accomplishing valid criminal justice needs, protecting harms to society. It should not be used because the government in power wants to be reelected and thinks that they will have a better chance at reelection if they start incarcerating particular groups of people. So that is a real concern I have, and the way you prevent that is through ensuring everyone gets to vote. Even people you don't like, just because this is a power that I don't want governments I agree with to have this power, because I don't want governments I disagree with to have this power. And once the government has the power to start picking and choosing who gets to vote, I don't know that that's not going to be used in ways that I disapprove of. And, consequently, I disapprove of all uses for it. I do not approve of that kind of limitation. So that's my personal reason for why I think that it is a good thing that prisoners are allowed to vote. I'll also, and I know that there's going to be some people who say, hey, Runkle, you're off base on this. Prisoners shouldn't be allowed to vote. But, if you think about it uh, in terms of how this could be abused, I am always skeptical of the government. And I think that that is an important element of being a good citizen, is being skeptical of the motives of government, because government sometimes abuses their powers. So, yeah, I have that concern. I really think that that's a problem, and the Supreme Court doesn't address that at all. And that was probably because it wasn't raised. But that is probably a basis that, were I on the Supreme Court, I would have, and before you start going in the comments, there is zero chance of that happening. It will never happen. It's just not on the table. But had I been on the Supreme Court there, I would have probably said, hey, listen, this is something we need to address. It is not up to the government to pick and choose who gets to vote. That is a power from the electorate, and Parliament only gets to act on behalf of the electorate because they have that support, and it has to be the support of everybody, not just of the people that Parliament decides get to vote. Some people say, well, what if prisoners start skewing the vote in various ways? Well, as noted, they're not all lumped into one place. But the other thing is, prisoners may actually have valid considerations in terms of, their own treatment, in terms of things that might affect their family members who are on the outside. These are things that might be valid considerations for them. But if you have enough prisoners that they actually make up a substantial proportion of the vote, where your elections are being, won or lost based on the prisoner vote, society's gotten screwed up. That is an indication of a failed society in some real ways, because we just shouldn't have that many people getting sent off to jail. That would be a distressingly messed up society, and I wouldn't want to live there. You shouldn't have 10% or whatever of your population incarcerated. That would be. So I don't really think that that is a real concern, that prisoners are going to skew the vote. They're going to play a fairly small role because they're a fairly small percentage of the social fabric. Anyway, yeah, I get that this is a controversial issue. Lots of people are going to say, hey, I suspect I'll have people in the comments saying, Runkle, I disagree with you here. Hopefully, and that's fine too, right? Disagreement is part of society, but it's at least good to understand why this decision came into being and the arguments, around it. So feel free to disagree with me. Let me know in the comments if you do. And, that's healthy too. But yeah, I think this is the right decision ultimately. I think it's a better way of setting up a society, but I'm not always right. So anyway, thank you for watching. I hope that this is, if nothing else, provided a little bit of an education and a window into how the courts make decisions about really important rights. We got to walk through a bit of the court addressing the Oakes test, which is it is sort of the toolbox for how the court deals with these kinds of rights issues. So if you come away with nothing else from this video, if you think everything the court has said is trash and everything I've said is trash, you still get to see the process for, what questions the court asks. And I think that that has a lot of value to it as well. In recent discussion, in terms of, people discussing the convoy protests and the convoy, whole thing, there's been a lot of people who are sort of mocking the convoyers for saying, hey, listen, you guys don't have a full understanding of the Canadian legal framework and constitutional framework. But that's really an indictment of our educational system. We just can't go through stuff like this in a high school class. So I think it's important as well to, give people the option at least to get some of the stuff that you might otherwise need to go to law school to really pick through, just available. That's one of the things I try to make available to the public, is just a better understanding of what our justice system looks like, so that we can have a better understanding of the good parts and the bad parts. Because there are parts, there are decisions out there, and if you look at some of my past videos, there are decisions out there that I really take issue with. And frankly, I don't agree with everything in this decision in terms of why they came to their decision. I think I've got a better reason for the ultimate conclusion than they did. And I mean, we can argue about, I think that the educative aspects are perhaps a little too arguable. They're too debatable. So yeah, it's a difficult case, but anyway, I hope you've enjoyed or learned something from going through it. I really appreciate you guys watching. If you made it this far, you're an hour deep into dense legal stuff. So congratulations and thank you for sticking with it. I want to thank as well my Patreon supporters at the $50 level: Jonathan Wheeler, Canada's National Firearms Association; Kyle Martin, the CCFR and the Canadian Shooting Sports Association; at the $30 level, Sights and Arms Limited and Marc-Olivier Damour; and at the $20 level, Peter Hilger, Mark Whittington, Jane Babin Luxor, Haywire, Dale Nesbitt, Cameron Johnson, Bruno R., Andrew Elsich, and Aaron Delso. Thank you as well to the $10 supporters who are in the crawl immediately following. Thank you for watching, and I hope this has armed you with knowledge.